professional responsibility is convened in the matter of Robert B. Fitzpatrick, board docket number 23-BD-035. Will the parties please identify themselves for the record, starting with disciplinary counsel?
Good afternoon, Efta Talontar on behalf of disciplinary counsel.
Robert Lee Fitzpatrick for the respondent.
Thank you. Let the record show that attorney members Michael Tiger and Sharon Rice Hicks are participating in this oral argument remotely via Zoom. We are here on exceptions to the hearing committee report from respondent, who will proceed first. You will have 20 minutes, Mr. Fitzpatrick. Do you want to reserve some of your time for rebuttal?
I have reserved 10 minutes for rebuttal.
10 minutes reserved for rebuttal. Before we begin, please be advised that pursuant to the protective order in this matter, the parties shall not refer to the clients in ways that could reasonably be used to discover their identities. With that, when you are ready to begin, Mr. Fitzpatrick, please do so.
Thank you, Your Honor. I'll be very brief. If you have questions, please interrupt at any time. I am retired from the practice of law. I have submitted the appropriate paperwork to the bar and has been processed. And in fact, I submitted the day before yesterday the first of 5 annual reports that need to be submitted pursuant to Rule 2, paragraph 5, and received this morning from the bar indications that I have fully complied with the first year.
And Mr. Fitzpatrick, how are you proposing that the board take that into account in this matter?
Well, I'll start with this. Retirement is not a get out of jail free card, if you will. If discipline is appropriate for past acts, even prior to retirement, then there ought to be discipline. The discipline of the board and the Court of Appeals is, I think, somewhat limited by one's retirement. For example, the ODC proposes here, the committee proposes that there be a 2-year suspension of myself with no fitness, or with fitness, which means you have to reapply after 2 years.
I don't think they recommended 2 years, but go ahead.
Whatever the
period of suspension,
whatever the request was, presumably can't be done anymore because the person is, myself, retired. Therefore, I think the board and the Court of Appeals sanctions are somewhat limited by one's retirement, as I said at the outset, and as I think the Court of Appeals has made transparent, that retirement is not a get out of jail free card. There still should be discipline.
Excuse me, Mr. Fitzpatrick, I have a question for you. I hear you saying here today that you've submitted paperwork to begin the retirement, but in your brief, you said that it's possible, although unlikely, that you may come out of retirement. So how are we to understand your position if you're telling us you're submitting paperwork to retire, but yet in your brief, you clearly indicate that there may be a possibility that you would come out of retirement? How are we to interpret this?
If I may, some facts. I'm 85. I lived in the same house for almost 40 years. Tonight, or excuse me, tomorrow night, for the first time in 40 some years, I sleep in a different home, a 2-room apartment in Montgomery Village, Maryland. I have no intention of practicing again. It is possible. Could happen. Somebody could call me up and say, I'll pay you $1 million, Fitzpatrick, if you would resume the practice of law. Okay? Would I say no? Of course not. Is that going to happen? It is improbable to the point of impossible. What am I currently doing? My email states right below my name, retired from the practice of law. Occasionally I get phone calls from prospective clients. The first thing out of my mouth is I no longer practice law. I got a call a couple days ago from a former client who wanted my advice. I said, I can't give you advice. I don't practice law. I don't give advice. I can give you referrals. I don't think that is practicing law. Tell me what your problem is. Told me in one sentence what his problem was, and I gave him 3 possible referrals. That's it. What do I want to do? What am I doing? I am writing an article about Ned Hanlon, whom I'm sure no one here has ever heard of, but my first love in life is baseball. And he used to be the manager of the Orioles back in the 19th century. And I'm writing that article for a conference at the Baseball Hall of Fame. I am also writing an article about representation agreements for lawyers and the good, the bad, and the ugly. How I think you ought to do it, with a disclaimer at the start that I'm not practicing law. There's no attorney-client relationship here. I am not giving you legal advice. I am merely stating what I think is the good and the bad and the ugly. What do I really want to do? What do I really want to do for the rest of my life? Is teach children. That's what I used to do in the last couple of years before I ceased practicing. I taught little kids pre-K up to about 6 years old, and I loved every minute of it.
Mr.
And
Fitzpatrick,
that's what I want to do, not to practice law.
Mr. Fitzpatrick, we have your statement that you're going to retire or that you are in the process of retiring. I don't want to get into amounts of money that might call you back. But I take it that you're saying that if the price were right, you would resume the practice of law. Is that correct?
If I could.
Okay.
If I
So
could.
let's get.
No, let me
Yeah.
please let me finish. If I could, first of all, there's this whole thing about fitness. And the court, let's assume you and the Court of Appeals buys into this fitness stuff. Okay. The Court of Appeals has also said, if we find after your suspension that you apply to come back and to overcome that fitness hurdle, that's a tough road to hoe. Okay. Secondly, if I were to practice law again, Okay, I have to have associates, as you can tell from reading my briefs. I need associates to help me with any writing. And it appears to me what is coming in terms of competence to practice law is AI. And I know nothing about AI. I had to ask my son-in-law, what the heck is Claude? I didn't even know. Okay? I can't practice law competently today. If I submitted a brief like I submitted to you all, the first or the last was better than the first. But both would be to the trash basket by any judge. It's not the practice of law.
So
So
Mr. Fitzpatrick,
it
excuse
is
me,
possible. But is somebody gonna come along and offer me enough to resume the practice of law?
Well, that's a very circumstantial hypothetical, but let's turn to Ms. Cassidy. Has a
so
question.
you reserved 10 minutes for rebuttal. So at this point, your argument time is over, but I do want to ask one question of you. So what is it that you're asking from us today? Like, what is your argument of how we should dispose of your matter today? If you could just briefly let us know.
I'm sorry to interrupt. I think I should get exactly what I should have gotten. What's it, 6, 7 years ago now? Okay, I should have gotten an informal admonition. I mean, I was stupid. There's no, I don't blame anybody else except me.
Okay. And so,
I'm the one, the buck stops here.
okay.
I'm the one whose name was on that letterhead. I am the one who did not refund on a timely basis monies to that clients had entrusted to me. And for some, it still hasn't been returned to date. I never touched a dime.
So Mr.
I
Fitzpatrick,
never stole from anybody, despite what a witness in this case tried to say about me. I
That is
never
not
stole
a
the dime.
matter with which you've been charged.
Right.
We're not considering any charge of misappropriation or theft. That's just not on the table here. Ms. Cassidy.
so thank you for that answer. So we see in your brief that you asked us specifically to remand the matter for an informal admonition. That's your request of us today, essentially.
I have read some of the reported informal admonitions in the Washington Lawyer. And it is shocking some of the things that people have done that have resulted in an informal admonition. The one that really sticks out in my head is a lawyer who failed to meet a deadline and the case was dismissed and the client lost their case. And they got an informal admonition. There's no standard. It's standardless. If I read this, goes up and down from, I think a pretty serious offense that is, to what others did. But there doesn't appear to be any standard that governs informal admonition. I find that troubling. I find that maybe a due process issue, but I don't want to go there.
Do you have any other specific matters or arguments you want to make in this opening argument?
I've reserved 10 minutes for rebuttal.
Okay.
Thank you.
Disciplinary counsel? And if you wouldn't mind addressing off the bat, how the board should take into account Mr. Fitzpatrick's statement that he has retired.
Very well. May it please the board. I will address that right off the bat, Mr. Walker. As Mr. Fitzpatrick said, he could, if a client walked in with $1 million, begin practicing immediately. When Mr. Fitzpatrick is still an active, well, not an active member. The last time I checked, it was noted that he was retired with the bar. But he is still a member in good standing with the bar. He can retire or unretire at any point. And so what we're seeking with fitness is to prevent him from taking that $1 million client when there are serious questions about his fitness to practice. In addition to general deterrence, consistency, the other reasons why we would want to apply the appropriate sanction and a finding of fitness in this case.
Please go ahead.
Thank you. So the findings in this case were thorough and supported by substantial evidence in the record. And we asked the board to affirm the hearing committee report in its entirety. The hearing committee concluded that Mr. Fitzpatrick violated several rules, Rule 1.15C and 1.16D, having to do with his failure to return unearned money, which Mr. Fitzpatrick admits to. He failed to maintain complete and accurate records under in violation of Rule 1.15A, which I don't believe there's any genuine dispute about. Mr. Fitzpatrick commingled the funds in his trust account in violation of Rule 1.15A, and he also violated Rule 8.4D. And what I'd just like to focus on today is the issue of the sanction. The hearing committee not only recommended a suspension of 60 days, but they found that Mr. Fitzpatrick's conduct, quote, or warranted a finding of fitness, stating that after, quote, thoroughly examining the record and observing him over multiple days of an in-person hearing, they were left with serious doubts that he would conform to the rules in the future. And that was their fitness finding. And so we asked the board to adopt that finding for the reasons that are provided by the hearing committee in its report, but in addition to some of the serious doubts that still persist today. Number one, Mr. Fitzpatrick is still holding on to client money, as I think he just stated. He said that he hasn't touched this money. This unearned money needs to go to the clients who he owes the money to.
Excuse
yes,
me,
Ms. Cassidy.
how do you procedurally recommend if the board were to, as you're asking or suggesting what needs to be done, the money returned to the client, what role or what procedural mechanism is there for the board to undertake such an action through order of the board?
It's through the finding of fitness. Because prior to being reinstated, he will have to show that he's resolved these issues, that the client money has been restored, that his account has been remediated, that he is now ready to go out into the world and represent other clients, that $1 million client who walks through his door. He hasn't done that. The record has there's nothing in the, and Mr. Fitzpatrick states this in his briefing, but there's no evidence in the record that any of these clients actually received any of their money. Because as of the date of the hearing, we still had not received any evidence from Mr. Fitzpatrick that they had received the money. We did get some copies of some checks sent to the clients, but we don't have all the communications with those clients. We don't have copies of anything else that would prove that money left his account and would have gone to the client's account. So that's where we are today, and that's part of the reason why we're asking for a finding of fitness. And I'll note that this has persisted for so long. This has gone on for over a decade now. This has gone on for so long that some of these clients, Mr. Fitzpatrick says he's lost track of. He doesn't even know how to reach them. And so I think that a part of those future proceedings that would need to be addressed as well. It was supposed to be a part of his plan of action that he was supposed to tell us who he could find and who he could not find. He never did that, or at least he never did it completely. So as far as Mr. Fitzpatrick's recognition of his misconduct, I think that the he stated that he fell asleep at the switch. But to date, he still has not provided a real explanation of what happened here, of why it went on for so long, why, despite all the warnings, he didn't give the money back to his clients when he should have years ago, or why he wasn't able to, or why he had such a prolonged and repeated disregard for the disciplinary process. So all of those we submit provide further basis for a finding of fitness.
In ODC's position, has Mr. Fitzpatrick taken responsibility for the commingling?
Has he taken responsibility for the commingling? In some respects, he has admitted that he did admit that he owes certain clients money. And really, there's been no challenge of the finding that those were unearned funds in the account. However, he still is challenging the fact that there was earned money in the account. I don't know completely what to make of the argument because there really aren't really a lot of specifics behind it. But he is still challenging that commingling, the commingling accusation without really providing very much support or his own analysis or his own math about what exactly happened with this account. And I'll just note that our investigator who testified credibly during the hearing, she provided a complete analysis. She spent over a year trying to piece together Mr. Fitzpatrick's account during the investigation, but she testified credibly that there was about a third of the account that was earned money, a third of the account that was unearned money after her analysis, and there was maybe approximately a third or a quarter or so that she just could not explain. We don't know who the ownership of those funds are.
May I ask, getting back to sanction for a moment?
Yes, sir.
Could you think of, or is it possible to craft a sanction that would require a respondent to retire as a probation condition following a period of suspension?
I'm not aware of a precedent for that. But I think that of the tools that are available to us, the tools that would be most consistent with the precedent we have, the fitness requirement is it. It's not punitive. It's just saying that prior to his reinstatement, he has to prove that these issues have been resolved and that he's ready to represent other clients. I mean, in sum, Mr. Fitzpatrick cannot be trusted to ethically handle client funds or to conform himself to the rules in the future. And that was one of the findings of the hearing committee. And thus, the finding of fitness is appropriate here. We asked the board to adopt the hearing committee's recommendation of a sanction of the suspension of 60 days. We think that's within the range of Toppelberg. It's maybe in the middle or even on the low end of the appropriate range. His failure to return the client money alone would fall within that range consistent with the Toppelberg decision. But we also look to the factors that are present here, which consist of the seriousness of the misconduct, which went on for a decade and was compounded by his failure to cooperate with disciplinary counsel in light of other aggravating factors, including the fact that Mr. Fitzpatrick has prior discipline, which he says he doesn't remember, but there is prior discipline, which involve very similar facts to what we have here. And finally, a lack of mitigating circumstances. So all of the hearing committee's findings are supported by substantial evidence. Mr. Fitzpatrick has provided no arguments to the contrary, including his arguments today, and the clear and convincing evidence supports the violations found in the hearing committee's report. So we ask the board to affirm the report in its entirety.
Thank you.
Thank you.
Trying to respond to a question that was asked, why? Okay. And you've heard many, many times, asleep at the switch, I blame no one else, stupid, stupid, stupid me. But there was what I think is significant here is his office did not comply with the rule with respect to money that had been entrusted to the firm. No question about that. Okay? And when it was called to our attention by the bar, we immediately said, badly run. This was not an appropriate way to run this law firm. There is not a scintilla of evidence as to who, other than me, and my name was on the letterhead always. And so the buck stops here. But there is not a scintilla of evidence. I'm moving to the commingling issue, which I think is borders on frivolous.
You should keep in mind, Mr. Fitzpatrick, that the hearing committee did find that there was a factual basis for that and for all the charges.
There's not a factual basis for commingling unless we want to turn upside down the rules of the bar. Are we going to say that a lawyer who never billed the client for the work, never took a dime from the client for the work that the lawyer had done for the client, therefore commingled, no bill, no opportunity to dispute the bill?
I think you have to add to that question. Would you say that about an attorney who did not return money to a client that was unearned after the work was completed?
No question. Here.
Well, additionally, Mr. Fitz.
I'm sorry.
Yes, Mr. Fitzpatrick, we understand that argument that you've been making, the fact that you didn't invoice the clients and therefore the funds cannot be commingled. However, there's also, you're also charged with record violations. And does not the invoice, a issued invoice to a client, go to the accuracy of your books and records so that a third party can reconcile what's going on in your statements, and a failure to bill is part of your record violation? But here you seem to argue that it's why you could keep their money in perpetuity. At least that's what it looks like to the board. Can you elaborate on why that is not just another facet of the record keeping?
Two responses, Your Honor. One, everything is collapsing in front of me. If I was aware that I was that I wasn't even sending out a bill to a client for work that had been done, I may look stupid, but I'm not that stupid. I would have billed the client. There is not a scintilla of evidence as to who prepared those bills, who put draft on one or more of those bills. We don't know. There was no testimony taken of Ms. Salzberg. No effort apparently made to even find her. A subpoena served on Mr. Bendet's firm. Not a scintilla of evidence, not a single solitary document was at least turned over by ODC to me as to what it got in response to that subpoena. I assume, I'm being charitable, I assume it was nothing, that Mr. Bendet turned over nothing. Okay. It was stupid on my part. Should I, going to the suggestion of a suspension and then an order that I retire and never practice law again? For this offense? I don't think so. I think it's way, way, way too severe. I'm not to be trusted. The committee says I'm not to be believed. I'm dishonest. I'm a liar. 50-some years of practice of all the good I did, and someone wants to say that I'm not to be trusted. I'm a liar.
I think the
I'm
finding,
sorry.
Mr. Fitzpatrick,
just-
was that it was a finding that you were not credible as a witness, not that you were a liar. And one does not necessarily entail the other. Right? So any further arguments?
Yes. Trying to stand this machine back up. Going back to what I think was asked at the start, and that was why. If my motive was pecuniary, if my motive was to steal, like many of the cases that involve what I'm charged with, it's the lawyer using the trust money and the lawyers in the operation of the lawyer's business. That never went on here. We never touched a dime. There was no pecuniary motive. There was no evil motive. There was stupid, yes, but stealing, no. And therefore, to say, because he was dumber than dumb, he should not only be suspended, even though I don't know how you suspend someone who is retired, but lawyers and judges always do magic. So let's assume I can be suspended. I think that's not the appropriate remedy here. I was not motivated by wrongdoing. If you talk to any lawyer or any judge who dealt with me in this town, credible, trustworthy, honest, every single solitary one of them would say Fitzpatrick was a stand-up and is stand-up guy. I'm sorry if I overwent my time.
Thank you, Mr. Fitzpatrick. The case is submitted.